So this is the Minnesota Male Treatment Intake Screening and Response Path Guidelines. So when a probation officer winds up doing a mandate report, kicks it over to Child Protection, this is the guidelines they do their screening by. Needless to say, it was obviously not done like this. I'll also put a link to a website where you can download this. person considered including in a family unit responsible for a child's care include all residents in a household, adult and children ages 11 or older, when an older child is responsible to provide basic care, supervision, an adult who resides of the home at the time of the alleged maltreatment but no longer resides with the family. Person considered including in the definition of significant relationship includes only applies to sexual abuse cases. Parent, step-parent, guardian, brother, sister, so on, so forth. I'm sure you can read that. Adult who lives or stays intermediately or regularly in the same house, apartment, or other dwelling. Intermediately includes, but is not limited to, frequent but discontinuous stays across time. Reports on a parent or household member who is registered or requires to register as a predatory offender must be screened in as a sexual abuse allegation and therefore receive a family intervention response. This includes parents who do not reside in the child's primary household. Each and every time a new child is born to the predatory offender or living in the same household as a predatory offender, a new report is required and needed a new family investigation. Minnesota Department of Correction is required to notify local child welfare agencies before authorizing a person required to register as a predatory offender to live in a household where children are residing. Threatened sexual abuse. Threatened sexual abuse, which is interpreted for the purpose of these guidelines to include, but not limited to, anything said, done, significant danger, a person who has sexually abused a child based on prior maltreatment, discrimination, or current credibility residing with the child. Allowing a person who has sexually abused a child to reside in a home with a child or have unsupervised contact with a child. Needless to say, this was not done. So like I say, I'll put a link in this video so you can look through it if you want. I just wanted to point out the basic stuff. It's got all the legal definitions, statutes through it all. Here's the statutes. Part 1, step and handling reports of registered predatory offenders, accepting a report and assigning to intervention, assigning to an investigation. So number 6 on here. This is statute 609.343 subdivision 1 H 32 2004. That's a statute under Jeffrey Watney, what he was charged for his criminal sexual conduct, for being a pedophile, touching his own kid, molesting his own kid. So there's a statute on it. Pretty self-explanatory. .343 criminal sexual conduct, second degree. Crimes required predatory offender to register under Minnesota statute. So from what I just showed you, and what they're supposed to do on an investigation to approve them to live under the same household with a minor child that's not even his. In 2008, this is what they did, what they consider a mandate report. Chrissy is aware of Jeffrey's pedophile status. If any problems, questions, concerns, due to regards of Jeff's pedophile offense, Chrissy will act on it and protect. Okay. Because Jeff has completed pedophile treatment successfully and has been living in the house with Kayla for 10 years. So this paper here is already stating that they were already living together in the same house for 10 years. Nothing was ever done prior to this. And due to child-parent interview, Dakota County Social Services does not appear to have any risk to Kayla. Number 4, Jeff can have unsupervised contact with Kayla. Like, that's what the intake was. That's what the child mandate report, that's what the screening is. Of what I just showed you, this is what they got out of that. They were already living together for 10 years. Nothing was ever done or said or even looked into. It was just approved by probation for them to live in the same building structure, but claim 2 separate units, whatever. One should have been done at that point. I should have been notified. They're well aware of they fucked up. It's clear as day. They don't want to admit it. They don't want to deal with it. But instead, they want to push it around, like to have Jeff file some restraining order and then get it so I can't talk about it or even bring it up or even question about any of this. Because I went and recorded all the conversations with child protection and the probation and county attorney and went and posted all them fucking conversations right up there on YouTube. Now they want to like shut it down and they want me to take it down and delete everything, and that ain't happening. That fucking ain't happening. When I brought it to their attention, instead of them investigating it, looking into it, and then getting back to me and letting me know, oh, yeah, they didn't do anything, but denied it, backpedaled, mislead me, call this person, call that person, and then break it down to, well, he ain't no violation, we ain't going to do shit, and we ain't going to talk to you anymore, and any more communication is just going to be in writing, whether by letter or email. How the fuck do they go and put a fucking pedophile around a minor child that's not even fucking his at such a young age and fucking act like it's okay? Like, it's not a concern? When he was fucking molesting his own child. Let's go put him around someone else's child? And they say they approved all this? Like, how the fuck do you approve it? You guys didn't even fucking do an investigation? Didn't even do anything. Just, okay, we approve it. Are you fucking kidding me? Like, me as a father, like, have fought so hard to try and see my daughter, and the courts didn't listen, they cared, didn't even question anything that I showed on anything. But put a block on me filing papers to try and see my own kid? Trying to get them to force her to bring my kid to a safety center so at least I could visit with my child? Even wound up trying to cut the bullshit between the two of us and having someone, an intermediate person, to pick up my daughter, to bring my daughter there, to bring my daughter back after the visits. Courts won't even do that. Cut the bullshit from her, cut the bullshit from me, and put someone in the middle just to do it, and we'll see where the problem is. To put someone in the middle, the county people, whatever the fuck it is, I said, I even offered to pay for all that. Nope. They put a block to me filing papers, said I got to write a letter to the judge, show them something different, significant, that I felt that I had grounds to even file papers again. And then they're going to send me a letter back, let me know if I had grounds enough or significant change that I could even file papers. I mean, how fucking ridiculous is that? How fucking ridiculous is that? And then to find out the whole time a fucking pedophile has been around my daughter. a fucking child molester that was molesting his own kid was around my own child. My own child that I couldn't even see, that they wouldn't even enforce for her to bring my child so I could see her or spend time with her. Never was a concern or problem or issue. Never have I ever had anything on my record that would have any concern whatsoever with me around kids. Ever. Never had anything on my record. But this fucking pedophile could be around my kid, live with my kid, and they approve all that shit. But I couldn't even see my kid or even have the courts enforce my ex to bring my daughter for me to see her. And now they want to tell me that I can't talk about this or speak of it or anything. Like I'm supposed to just delete all this shit. And are you fucking kidding me? Fucking not happening.